Hello, everyone. My name is Wayne Outten. I am the founder and chair of Outten and Golden in New York City, which is the largest firm in the U.S. that represents employees and executives. It's great to have you all here with us for this very interesting program. So, about 12 years ago, my friend Paul Daniels and I co-founded the Lawyers International Network for Employees and Executives. We call it LINEE, to establish a network of lawyers in various countries who focus primarily or exclusively on representing employees and executives. The goals of LINEE were and are to facilitate referrals to trusted colleagues in other countries, to foster co-counseling when appropriate, and to share expertise about representing employees in an international context. Those goals are served by today's webinar on whistleblowing around the world. On behalf of LINEE, I want to thank those who have joined us for this webinar, an illustrious group, as I said, and to thank the subject matter experts who are on today's panel. Our webinar will be moderated by Paul Daniels, a leading practitioner in London who represents employees and executives with a particular focus on representing whistleblowers. Paul, take it away.
Thank you very much, Wayne. And if I may remind everyone of Wayne's own stellar career in advising executives. He's too modest not to mention his own career, but he's truly a preeminent lawyer for executives in the US, the leading firm in the US, or certainly one of the leading firms in the US for individuals. And he's been a leading lawyer since 2005 in all of the key independent directories. So it's been a true pleasure to become a friend of Wayne and to work with him. And he's a truly fabulous lawyer, as are his team. I'm absolutely delighted that we have Baroness Susan Kramer to join us today to lead off discussions. She has had a truly illustrious career herself. She has not just been a member of Parliament, successful member of Parliament. She is now a life peer in the House of Lords of the UK government, or UK, the UK political system. She was also very successful in the financial services sector, where she became a VP at Citibank in Chicago. And has truly got an amazing breadth of experience of the industries across the board that we work in. But in recent years, I've been incredibly impressed, and I have a huge admiration for the way that she has pushed whistleblowing as an issue where improved legislation was required, especially in the UK, where there has been a defective UK system which does not have the reach and the breadth and the power of the US system. And Baroness Kramer has been tirelessly working to introduce a whistleblower office in the UK. And seems, particularly in the last few months, to be making real progress with the political movers and shakers in terms of trying to get this into law. So I would love, I'm so glad that Baroness Kramer, I believe that Susan was having very high level political meetings earlier today. So I'm so thankful that you managed to get here. I know it was very tight for you, and would love to hear your perspective to start off with before we move on to many of the other colleagues and get questions from the room, where we really want people to pitch in from all of your places and with all of your perspectives. But we'd start off with an overview of the mission in the UK and how Baroness Kramer sees the current situation for UK whistleblowers, please.
Thank you so much. And Paul, you are way too kind to me. But I am a member of the House of Lords, and I have been driving on this issue of whistleblowing for a long period of time. I come to it initially from experience in the financial sector, and share the view that I think is held in common across the United States, that with an industry so complex, that with an industry where there is so much money at stake and so much opportunity, the regulators can never discipline this industry and properly monitor and supervise it without whistleblowers, that they're an absolutely critical part of the picture. And we live with the stain in London of being known as the London laundromat, because the inability of our regulators to basically keep discipline across the financial services industry in a whole lot of ways, international money laundering just being one of them. But it is hugely evident, and I think it is a real stain on our particular industry. So for everyone's sake, we need to make the UK a place that is welcoming and supportive of whistleblowers, rather than our current situation where, despite some legislation that's in place, in effect, many whistleblowers, that they lose their careers, they're blacklisted, that the issue is treated as an employment issue. And so the existing legislation only covers employees' rights to go to an employer tribunal. Those tribunal activities can stretch out for years as employers have a great financial advantage, can hire the best counsel in the country, and can make sure there are a constant series of appeals that make the whole process pretty much untenable and destructive for people who actually blow the whistle. We have made some progress generally. A lot more companies have in place now their own whistleblowing channels. In many companies, those are effective and respected. But of course, that doesn't include a very significant number of players. And it's particularly weak within the public sector, which is a huge employer for us in a way you may not think of it being in the United States. But for example, the National Health Service is, I believe, the largest employer in the UK, if not one of the largest across Europe. And that's an area where we've relied particularly on whistleblowing to expose that sometimes incredibly severe wrongdoing. Where we stand on this is we've managed to get this issue raised to the level of general political notice. We are facing a general election later this year, and so all three of the major political parties are reasonably have paid some attention to the issue. The government has promised us a review, which is due to be completed and report back, we hope, within the next few weeks, which will examine the existing legislation. That legislation is called the Public Interest Disclosure Act. And so I say it's limited. It focuses only on the issue of disclosure, and it focuses only on employees and creating the opportunity and basically regards any retaliation against them as simply an employment tribunal issue and nothing to do with any of the regulators. So we want to learn from you. The proposals government will come back with will be debated, they will be examined, they will be challenged, and they will be discussed. And the more strength and example we have from all of you on what works, where we should push, what are the really important elements that we need to have in place, the better armed we will be. And we need to take those who, like me, care about this issue are completely cross-party. It's not party political in any way, but we need all three of the major parties to face up to it in the course of this general election and to make commitments that they will put in place effective and meaningful legislation if we can't get something through earlier than probably the autumn, which is when the next general election will take place. Shall I stop there? I've talked enough, because what I really want to do is listen. I need your advice. I need your sense of priority. I need your direction to further on what we actually do.
Just can I ask one follow-up question, Susan, which is, where do you think your priority is in terms of the bill, and what is, if you like, the non-negotiable side of what you want to try and bring forward?
Well, what I suspect is that when the government comes up with its review of the existing whistleblowing framework, and I hope I'm wrong, but I suspect it will take the existing legislation and try and so it may try and put in some sort of provision that would mean that there was some degree of protection. There was a safe space for a whistleblower to go who was not an employee. But I'm not sure it will go much farther than that. And that's my great fear. We actually think we've got to have a root and branch change here in the UK. And we are very focused on creating an office of the whistleblower, because there's huge complexity, many different regulators, huge complexity, and only an office that is committed to providing protection for whistleblowers, protection against retaliation, that will ensure that if they are being damaged, a safe they can go to, a number they can call if their industry sector routes are not appropriate. So only if we have that kind of structure so do we have a hope of really breaking the current constraint that many people who know that there is wrongdoing are afraid to speak out.
Do you have a sense of what level of political support there is for the office of the whistleblower? And because this, I think, would be transformative for UK law. Do you? How optimistic are you, just in terms of the tea leaves, as to how whether we can get that sort of structure in place?
I suspect that we probably can achieve. I'm probably being very optimistic here. The idea of a separate whistleblower within the office, within, say, the financial regulator. We might be able to get one within the health service or whatever else. But we're afraid from our past experience that those would end up being under-resourced and inadequate, and still leave the sort of complexity and confusion that currently exists in the UK. Remember, we don't have the equivalent of a reward system, which basically means that people can go. We don't allow people to give people the prosecution. So we are very dependent on the behaviour of the regulators. See the Office of the Whistleblower as the mechanism to drive forward their work in this area. I definitely think we can make progress. Marching off the whistleblower, my ideal, that I'm not entirely clear. But I think that in some sectors, say financial sectors, we might be able to get something.
That's really interesting. In a minute, Corinne, I might ask you if you have a perspective, because I know through your experience, the UK side of things, where what particular problems there are for those representing UK whistleblowers. Clive, do you want to just briefly talk about the UK system and to cover why the current system is not operating very effectively?
I'm happy to just say my main gripe, which is when you're an individual bringing a whistleblowing claim, however good your claim is, and often they're pretty good, your career is so damaged, especially in financial services, and you have no protection going forward. You may have your claim against the employer who's treated you worse because of your whistleblowing, but out there in the job market, there's so little protection. And I would urge so much focus to be on that aspect, because these people, their careers can be shredded simply because they've blown the whistle. And it'd be interesting to compare that treatment with American treatment and Italian treatment, Swiss treatment, etc., just to see how much protection there is in the market, job market.
Yes. Corinne, are there any observations you would like to share about the challenges for UK whistleblowers with the current system?
Yeah, I mean, I agree with what Clive has said, really. It's monumentally difficult. You find that where you're the whistleblower and the employer, that they may have a sort of designated person who's responsible for the whistleblower, but often employees find they're blocked, they don't get anywhere, and they're very concerned that they're suddenly going to get unfavourable treatment. The ultimate remedy of being a tribunal claim, which may last many years, which is expensive to pursue, which is probably likely to end your job, with a statistic in tribunal that generally whistleblowing claims have a very, I think it's something like 6% chance of success if they're actually fought. So all of those issues act as a great deterrent. Plus the law is very difficult. It's the causation issue, where you may be a genuine whistleblower, but they'll say, well, actually, the detrimental treatment you've suffered isn't connected with your whistleblowing, and therefore, your claim will fail. And it's very disheartening as a lawyer acting for individuals, because you feel that really there is very little by way of remedy. So I think, whilst we have the law in place, it really isn't offering any sanction or protection to whistleblowers.
Yes, and I'm still, that's so true, Corinne, and I'm still trying to see if we can get Georgina Halford Hall on. She sends her profound apologies for being delayed today, having been in various political meetings earlier. Georgina is a tireless and fabulously energetic campaigner for whistleblowers in the UK and the chief executive of Whistleblowers UK. But she is currently indisposed and can't get into the conference due to some sort of enormous traffic jam. So Georgina's perspective of the challenges for UK employees is not currently available to us. But I think I would echo what Clive and Corinne are saying, is that a UK whistleblower basically has to risk their career and their livelihood and incur legal costs with the chance, just the chance, that if they win the case, they might get back to where they were before by getting compensation for what they lost. Nothing, no positive, and very rarely actually the whistleblowing being addressed or solved. And I'm sure that that's one of the themes that Georgina would have raised had she been able to make the link. I'm still hopeful we can get Georgina, and we're swapping messages as we speak. So the UK system is flawed. There is potentially cavalry on the horizon in the shape of Susan and her colleagues pushing to make the change. There's a new election likely to be in by November of this year. So that watch this space in the UK. I think we are likely to get a change in the next 12 months. But what we'd love to now hear about is the US experience, which is chalk and cheese in my limited knowledge. The US system is incredibly interesting for us, and I'm delighted to introduce Dave Jochnowitz, a very successful lawyer at Outten Golden, to take us through a quick summary of where we are in the US and to contrast this with the challenges of the UK, mainland continental Europe, Switzerland, and other parts of our network. So over to you, Dave, please.
Thanks, Paul. I appreciate it. And I'm really grateful for the opportunity to be here. I'm going to share my screen and have some slides because I function better when I have slides. I'm not quite as eloquent as my UK colleagues. But and I will enter into presentation. So US whistleblowing law is quite different than what we're hearing from UK and what I've heard from some of my other colleagues across the ocean. The general rule, in the United States is just employment at will. You can be fired for any reason or no reason at all, unless it's a protected reason. And the United States has a variety of laws that do protect whistleblowers from retaliation for speaking up for violations of law. But it's important to understand that it is a patchwork. It's a patchwork at both the federal or national level and the state or regional level. There are some local laws that protect whistleblowers as well, but it's important to understand that there's no single law where you just say, I am a whistleblower under the whistleblower law. Federal laws, national laws tend to be very specific. So they're either industry or conduct specific. Securities whistleblowers in the financial industry can be protected under laws like Sarbanes-Oxley, which applies to public company or companies that are required to register with the SEC, with people who are raising concerns under a limited subset of laws under Sarbanes-Oxley. Dodd-Frank, which protects both securities and commodities whistleblowers. This law is, again, even pretty specific in that a whistleblower under this law has to have reported their concerns to the government in order to be protected under them. So it's both conduct by the bad actor, but also by the whistleblower. The whistleblower has to have reported to the government first. There are whistleblowers that protect, or there are laws that protect taxpayer whistleblowers raising concerns about violations of taxes. And then there are just an enormous number of individual whistleblower protection laws that cover specific types of employees. They can be defense contractors, they can be government workers, they can be people raising concerns about anti-money laundering, they can be people raising concerns about fraud against the federal government. There's an extensive list. But it is a patchwork. They all operate under essentially the same framework, though. You have to have raised a concern about some sort of illegal or improper conduct, you have to have made that concern known to your employer. Your employer has to have taken a negative action against you, and then the reason for that negative action has to be that your protected conduct. There are also state laws. I won't dwell too long on this. These state laws protect individuals who generally live or work in these states. New York and California have very expansive laws, but again, this is part of that patchwork idea where, it's New York 740, which protects broadly whistleblowers. It only applies in New York. California's Labor Code 1102.5, which protects employees who raise concerns, generally only applies to California employees. Most of these retaliation protections apply to United States workers, people working in the United States or who have some sort of jurisdictional claim in the United States. But whistleblower reward laws in the United States apply globally in most instances. So while a whistleblower who's suffering retaliation, which is the most immediate personal effect, and lives overseas might not be protected, they may nevertheless be eligible for a reward. The United States has a fairly robust set of whistleblower reward programs, but they fall into certain categories. So the main categories where the United States will pay rewards to whistleblowers are in securities fraud, commodities fraud, fraud against the United States government, and tax fraud. There's also a relatively new program for anti-money laundering, and there are other smaller programs relating to things that most likely only apply domestically, like car manufacturers in the United States and things like that. Whistleblowers have to provide information according to procedures in these reward statutes, specific procedures in these reward statutes. The government prosecutes these claims in general. In general, it's not a private lawsuit. There is an exception for that for fraud against the United States government, although that likely applies less to international whistleblowers, not always, but generally. And whistleblowers are usually eligible for between 10 and 30% of the money recovered by the government. So it's not a fixed reward. It's not you get $50,000 or 50,000 whatever if you report this fraud. It's that you are incentivized to report bigger frauds because the rewards can be substantially larger. And while there has to be some connection to the United States, whistleblowers can be from anywhere and conduct can occur anywhere, which is one of the most interesting things about these programs. So probably the biggest example is the Foreign Corrupt Practices Act, in which the United States extends jurisdiction essentially worldwide for U.S. companies or companies that are listed on U.S. exchanges that pay bribes to influence foreign officials to undertake official acts. These penalties can be extremely substantial. They have, and they've frequently resulted in whistleblower rewards. In 2014, just one example, the United States Securities and Exchange Program paid $30 million to an overseas whistleblower who reported violations of the Foreign Corrupt Practices Act. Although most U.S. tax cases will be in the United States has an interesting tax regime that potentially applies all over the world, and there are requirements for companies and banks operating overseas. And in one of the most striking examples, the United States paid a whistleblower over $100 million as a reward for reporting fraud by the Swiss banks. This was a United States person, but it was dealt with primarily overseas misconduct. And although I said, somebody.
The person is well known here in Zurich, yes.
I imagine he is in Zurich. Well loved, I imagine. And I mentioned earlier that most of the fraud against the government claims would happen in the United States, and that's true because most fraud against the government in the United States relates to healthcare. But there is substantial, as I'm sure everyone is aware, United States presence overseas, particularly through the U.S. military. And just recently, in a 2023 settled matter, a defense contractor paid over $100 million to settle charges relating to Iraq war fraud, and two whistleblowers in that case shared a $30 million reward, or an over $30 million reward. So whistleblowers it's important to understand that although these are U.S. laws, and as long you just need a nexus to the United States, and you could potentially have a client who's overseas blowing the whistle on a matter that they could get a reward for. the one thing I want to talk about is that it's a little hard sometimes to talk about my own success cases. It's hard for SEC whistleblower attorneys to talk about their success cases, which is a good thing and a bad thing. The reason we often can't talk about them is that the SEC's whistleblower program, which applies to financial fraud, and similarly with the Commodity Futures Trading Commission, which applies to commodities fraud, which are potentially international frauds, provide robust anonymity and confidentiality protections. So a lot of the concern with being a whistleblower is it does destroy your career. But under the SEC and CFTC programs, it's possible for a whistleblower not only to report to the government, but to report to the government and receive a reward and receive potentially millions or even tens of millions of dollars and never have their name become public unless they so choose. The fact that even the matter that they blew the whistle on, while the existence of a reward, say for $100 million is public or for $30 million is public, the exact reason for that reward is not even made public. And most whistleblowers, as a result, will choose to remain anonymous. And so whistleblower attorneys often have to speak about their successes in very
Is that incredibly frustrating, Dave, that you might have several years representing a US executive, you deliver a huge amount of support, emotional, legal, and in the end financial, and then no one ever learns about it? How does that feel when you finish one of those cases and it's just keeping mum, as we say in the UK, about the whole thing?
Yeah, it can be frustrating, but I would say that the advantages, being able to tell clients at the beginning who otherwise would not have come forward, and you would never have had the case in the first place if their name had to become public, is probably worth the trade-off. But yeah, I love talking about my cases, and I love getting into the details, and so it's very frustrating to not be able to speak about them.
Yeah, we had a very high-profile case in the UK where the head of the bank conducted a witch hunt to try and find out the identity of the key whistleblower. And, you know, the difference with the US where you get guaranteed confidentiality, whereas in the UK, eventually regulatory sanctions were made against the chief executive for abusing their position. But I mean, it's just so different in that context.
I'll give one quick example just of a case that I'm working on right now. I have a client who is overseas and has a matter where they are still employed at the company, and the company is aware of an ongoing investigation. And you know, the commission is taking, the SEC is taking real steps to protect this person's anonymity because there's a limited number of people who it could possibly be, but it's not only one person. And so the commission is very much aware that if they go and conduct their investigation in a certain way, it will likely expose this person because there is a pretty substantial US nexus for this particular case.
On that, so because our regulators here in the UK say of, you know, well, the whole structure of the UK system at present is around the center of it is to provide confidentiality. Here are a series of people you can go and talk to, the regulator, your member of parliament, and whatever else. The discussion will be completely confidential. That's, your name will never be disclosed. But I think a great number of our whistleblowers have found that they're pretty easy to identify. They're easy to identify because when they saw something wrong, they raised the issue internally. They talk to colleagues, they talk to a management chain of their employees, of their suppliers. In the same way, they raise the query in some way that makes it clear who they are likely to be. And therefore, they're suddenly fired from their job, or they suddenly don't get the promotion. They go to an employment tribunal and then try and explain that happened because they blew the whistle. But how effective is confidentiality in the cases that you look at? We're finding it's a pretty weak read.
Yeah, I think it depends on whether and the extent to which they have already spoken up internally. So if they've spoken up internally and then 6 months later a regulator comes knocking, the logical assumption is that it was that person. The reward programs have a bit of tension because there is this desire for encouraging people to speak up internally, and the retaliation protections are meant for that. But I mean, it's spot on that companies, one of the first things, my understanding, that they do is put together a list of people who it might be, which the non-nefarious explanation for that is, of course, well, we need to think about what the scope of the exposure could potentially be. The more nefarious reason being, well, we need to get that person out of here if they're still here. I do think that in some cases it is a fig leaf, but I will say that it's not always, and sometimes the right hand and the left hand take a while to speak to each other, and so when that happens, there can be an advantage when, you know, the people who are responding to the regulators don't necessarily talk to the right person who tells them, oh, this was so and so. We know this was so and so because so and so raised concerns about this, and we terminated them 6 months ago for raising these concerns. Which, yeah, we shouldn't have done that, but we did it. And in that interim period, there can be some really productive investigation. It eventually, I mean, I will say that one thing that is really positive is that definitely affects the whistleblower in their current situation, but when there's a massive whistleblower reward, some clients, you know, can choose to retire to an island, but those that can't, those that get more modest awards, but still substantial, but more modest ones, can continue their careers potentially, you know, with a severance agreement negotiated with the former employer to not badmouth them in the industry. And then the fact that they've done this is never made public. And so it can allow them to continue their career in a way that they might not otherwise have to do if they have to file a very public lawsuit. Yeah.
Got it. In a minute, I might invite Mary to add a comment. But I would also love to hear from any of the other US experts, Cleveland, Cody, Ed, Gerald, Anna, Austin. Those are some of the names of those who I know are US based. So I'd love in a minute to hear from any of you, and really welcome potentially all of you to have a comment. And Mary, would you have a comment to make about why you think the US system works? Would you have some view on that?
Yeah, I mean, thank you, Clive. Thank you, Paul. I always think of Paul and Clive as a double act, because you are. So I think one of the things, I think people are often too reductive about, particularly on the other side of the pond, about what American programs are, and they reduce them just to rewards. And the thing that I always like to point out is we're much more than just rewarding whistleblowers. It's sort of the cavalry that comes behind the whistleblower. So I love the analogy, and we've had the distinction of bringing folks from the CFTC whistleblower office to Parliament in the UK. And Melanie DeVoe, one of those enforcement attorneys, says, what whistleblower lawyers do in helping whistleblowers is help them to bring cake in a box to the enforcement agency. So if you, like Susan is intending, have an office of the whistleblower, you're going to get inundated with hundreds of thousands of tips that are going to come in any state of disarray. And one of the things that, even though you don't need to have a lawyer to bring a tip to the US whistleblower reward programs, those who do actually come prepped for their interview with the government. The documents are all organized and by relevance and indexed. The memo that accompanies the tip includes all the legal standards, and basically becomes a legal brief and a prosecution memo. So when I talk to parliamentarians about why I think our program is effective, it's that it not only brings insiders typically and outsiders within companies to the agency with invaluable information that's a roadmap to the fraud, but it brings these team of lawyers behind them to provide extra resources to an under-resourced, strapped government agency like the Financial Conduct Authority or the Serious Frauds Office. So I guess that would be a point that maybe gets lost when people see these gobsmacking amounts of rewards that whistleblowers can see and receive in the US. They sort of stop there and think about it in that way. I guess the last thing I'd say is that I think the UK in particular feels like it's an American thing to pay rewards, but of course the Competition Markets Authority in the UK pays £250,000 for whistleblowers. We got our idea of the False Claims Act from the United Kingdom. It's your idea. We just stole it and are selling it back to you. And even in the UK, you allow private attorneys to bring private prosecutions in the criminal context. So I don't want it to feel like this is all an American idea. You guys have a lot of the ideas. We've recycled them and used them. So I say that because we now know that the head of the new Serious Frauds Office is now calling for rewards to whistleblowers, which he does as a former, I think, Met police officer or law enforcement, that it makes sense to pay confidential informants.
That's very interesting. Yeah, go ahead, Susan.
I was going to say, I think you're absolutely right. We've lost the point of that additional resource that comes with, in effect, the triage and the organization and of material and assessment of its significance that happens through the legal system. And I think we kind of have somewhat overlooked that in the way that we've been trying to design things in the UK. So any of your thoughts on that would be very much appreciated. There was also an earlier point that was made about the sort of patchwork nature of things in the States. And of course, it happens that way when things evolve by themselves. But if you were starting from the beginning, would you put in place that same patchwork? Or do you think that there is a role for an overarching body that sits at various regulators to try and issue? And would that make a difference to the whistleblower in terms of making it far clearer, far easier, far safer to actually report?
If I may, I'm going to throw that to the other US experts in a second, because I think that's a great question. But I wondered if, Dave, I think you wanted to come in on one more feature that has just come out of the immediate discussions.
Yeah, I think it's just to follow up. I had the opportunity to work with Mary very early in my career and learn from her. So I learned about the importance of doing that triage and thinking about it and making sure you're presenting your strongest case, because these agencies do get thousands and thousands of tips, and even under more stringent programs that have higher standards, even if that have higher procedural standards like the False Claims Act, there's still hundreds of cases filed a year. So being able to collaborate with law firms that are experienced in this is really critical. So if you do have somebody overseas who has a matter that has a US nexus, I think it's really important to reach out and partner with experienced law firms that work in this space, because the difference between putting in a tip and hoping for the best and making sure that you're using all of the best practices to try to make sure it gets in the right hands is the difference potentially between a successful case and an unsuccessful case. And Mary's obviously spot on. And just one quick response about the patchwork nature of things. I think that there are positives and negatives the closer you are to subject matter experts and to what's going on. So at a given investigative agency, there can be advantages to that. But the patchwork nature also means you get totally different experiences. So, for example, in the United States, the Securities and Exchange Commission is generally, in my experience, a little bit better of a partner in protecting whistleblowers, in working with whistleblowers and working with whistleblower counsel and understanding the value that whistleblower counsel can bring. I do not have a tremendous amount of experience with the IRS whistleblower program here in the United States, which the International Revenue Service, the taxing authority here. But my understanding is that partnership is sometimes less good than with the SEC. And so I do think an overarching view would potentially be helpful. I think that if starting from scratch, I think there's potentially a way to do it. But again, it's a matter of resources and trying to make the most with limited resources, and local context, I think, matters.
Right. I think in addition to Mark, Matthew, and Andrew, who I rudely omitted from my little list of US experts in a minute, I'd love to hear from any of you, and if Cleveland, Cody, Ed, Gerald, Anna, Austin, if you have some particular perspectives both on Baroness Kramer's point, or indeed the other background, it'd be fantastic to hear from you at this stage.
This is Cleveland. I can comment on a couple of the points that have recently been made. Picking up on one of the issues David mentioned with respect to, sort of the tension between internal reporting and reporting out to the government and exposing oneself to potential retaliation. I was, sort of fortunate enough to be at Taxpayers Against Fraud when Dodd-Frank was coming online, when some of the other subsequent agency programs were being developed. And I think what we've learned is that the vast majority of whistleblowers, and I've talked to thousands in my capacity as a nonprofit person, as well as now in private practice, the vast majority of those people, come in the door as employee clients. They're retaliation issues. They've, swam upstream. They've tried to speak up. They've tried to stop some practice that they knew was wrong and have suffered because of it. They're not folks who are avoiding that process. And so what we have seen develop in the US laws, where whistleblower rewards are generally within a range, as low as 10 or 15% and usually up to 30%. There isn't an internal reporting requirement, because industry said, well, people will just delay and let damages build up. No one will ever give us an opportunity to fix this. That's not whistleblowing. And then, regardless of the fact that that's not what actually happens, the agencies seem and Congress seem to have taken that into account. And so while there isn't, generally speaking, a requirement that whistleblowers report internally, that's sort of a plus factor when determining where within that range their reward might lie, what extent they may have delayed in reporting, to what extent they may have, reported internally to try to stop that practice. With respect to the question of, whether we need like a clearinghouse or one central portal for whistleblowers to use, I do agree that the patchwork system can be confusing for folks, and that sort of exacerbates the need for legal representation in some cases where it may not always be necessary. But I think I'm less concerned about there being a patchwork of adjudicators and more concerned with the patchwork of protection. Some laws are more protective than others. Some of the programs, the reward programs, have guaranteed minimum rewards that are, the proper way to incentivize whistleblowers, versus other programs that, leave the entire reward up to agency discretion, and provides no real comfort for the whistleblower who presents their information to that agency. So I would like to see.
That's a great point, Dad. I think in the sense that that are there areas and industries where you're sort of a second-class citizen of your level of protection, and financial services in the US seems to have fantastic protection through money laundering and Dodd-Frank and Sarbanes-Oxley, but perhaps other industries don't quite share that, and that is a really interesting observation about how patchwork kind of actually produces levels of gradation. So I really appreciate that observation, Cleveland. That's very interesting. Sorry, I cut you off then.
No. I feel like I'm talking too much, and I want to give others an opportunity to chime in.
And Jason, I'd also invite an input from you. I'd love to hear from you, and indeed any of the other US experts, before we move on to the European dimension, which I think is important for us to take note of in a moment, and also some of the situations in Switzerland, which has its own particular nuances and is an interesting, perhaps cautionary tale about some of the experiences that whistleblowers in Switzerland have had. But I'd love to hear more from our esteemed US experts before we move back across the Atlantic.
I'll be brief. This is Jason Zuckerman. I don't know if people can hear me, but I want to go back to just something another speaker said earlier, that if you pursue your case in the UK for years, all you get is basically, your lost earnings, and so few people win. I'm happy to say that under US law, it's not like that. You can get non-economic damages, harm to a person's reputation. You can get reinstatement if the employer won't reinstate, will not reinstate, you're able to get some of the earnings you would have made in the future. But I do want to say that that point that was made earlier, that if you fight your case for years, you're not even truly put in the position you were in if there hadn't been an act of retaliation. I think we have some of that in the US too. And why do I say that? Many of you heard a few weeks ago, there's a holding by the Supreme Court in the Murray case, which has to do with how high of a burden is there to prevail in a claim of retaliation under the Sarbanes-Oxley Act. And for a while, it was clear what that is. It's a very low burden for employees. There was a panel, or there was a panel at Eighth Circuit, also a panel at the New York Court of Appeals that really got it wrong. And now it's back where it should have been. But it's important to note what happened to the plaintiff in that case. He worked at a bank. He blew the whistle on the fact that he was supposed to prepare a report that provided truly independent research. And there was this improper influence on him to try to skew his research in order to please a client. He blew the whistle on it. He wouldn't do it. He was out. He's been fighting his case for 12 years. He went all the way to trial, got about $1 million. The judge would not order UBS to reinstate. And even after he got a verdict of just $1 million, they fought him for years. They didn't appeal up the Second Circuit, then the Supreme Court. It's not even over for him yet. And the law firms that fought so hard for him, including a partner over at the Outten firm, at the end of it, they're supposed to be able to go to the court and get their legal fees after working on this case for years and years and years. But what happened? Their fees got slashed by the judge by about 1/3, even though the other side, UBS, had a lot of lawyers at the trial and spent all this money and basically gave a blank check to this big law firm. There was this judge who, I'll be blunt about it, has a job that's very secure. I don't know if she ever did any work on behalf of a plaintiff, and had to put millions of dollars of her work on the line. But somehow she can sit back and say, well, there was no need for the plaintiff to have all these lawyers there, even though the other side had all of these resources. So she slashed their fees by 1/3. My point being here is that if you are very creative in the US and you look at all the laws out there that may apply when there's been an act of retaliation, you might be able to do well. Under some laws, you're actually able to go to double back pay for the person, like under the anti-retaliation provision of the False Claims Act. But many of these laws do have various loopholes. And even when you have a very strong law, like the anti-retaliation provision of the Sarbanes-Oxley Act, would you actually go through the US legal process and you know what it's like to have to put your name out there where the judge is going to issue an opinion that's going to rehash all the arguments made by an employer, where you have to fight it for years, where even if you win before the jury, you then go up on appeal for years. I think the Murray case is really an example that it's not that much easier here than it is in the UK. Certainly our laws are a lot better. There are people who every once in a while get a huge verdict. But at the end of the day, it is very hard to get reemployed when your name is out there as having blown the whistle. And the US legal process, I think, has a lot of laws that make it very hard to pursue these claims. And until we deal with those flaws, it's still very, very, very much an uphill battle for
That's
people.
a sad tale to hear, Jason, and it's very interesting the perspective you've shared there. And I think perhaps it is a word of caution that we can get a little bit ahead of ourselves in terms of looking at the headlines and sometimes forgetting the sad stories of individuals not being successful or being overturned on appeal, or companies declaring bankruptcy as a way of avoiding paying in the US. And I'm familiar with many cases where that happens. I'm going to move back across the Atlantic to do the European dimension now. I would certainly welcome more input from our US colleagues in a moment, but I think it'd be great to see the framework of the European Whistleblowers Directive. In the LINEE network, we cover Spain, Netherlands, Luxembourg, Ireland, Germany, France, Belgium, and the UK. And those countries will have transposition of the Whistleblowers Directive into law across the member states. But also Italy is covered by the directive. And I'm delighted to introduce Cristiano Cominotto to you. He's the founder of Assistenza Legale in Milan. He's a fantastic lawyer. He's a friend of mine. He's incredibly active in the American Bar Association, and a true delight to deal with. But Cristiano is going to briefly run through to you the big picture on the Whistleblowers Directive in Europe and what the lessons and themes that we can learn from that before we again throw it out to the whole group.
Thank you very much, Paul, for the wonderful introduction. And I can only confirm that you are a good friend as well, and as well a wonderful professional. So when we are talking about Europe, we are talking, as you said, about a specific directive, that is the Directive 2019-1937. And so it's clear that we could apply the directive to all the European states that has to issue their own legislation. And I think that more or less all the states has already issued their national legislation. But in general terms, it's important to highlight the main point of the directive. What are the main points? The main points are that to whistleblow, you can whistleblow in Europe only within certain area. Okay, so not in every area you could whistleblow or you could report any kind of breaches. So what are the areas that are covered by the European directive? For example, the financial services, for sure, as we already saw even in UK and USA, the public health, the consumer protection, and I think that it's something that you already expect, and the protection of privacy and personal data. So who can be considered as a whistleblower? A whistleblower could be not just an employee. So what we expect normally when we are talking about whistleblower, we are always thinking that it should be an employee. No, it could be even, for example, a self-employed. It could be a shareholder. It could be a volunteers even that works for the company, even unpaid trainees. It could be even a contractors of the company. So I would say that everyone who can become in contact of any wrongdoing into the company could whistleblow in some way. So that's something that it is really interesting to understand. Another thing that to me it's really important to understand, because I have followed several cases, is that when we are talking about whistleblowing, we are not talking about something that is about a single person. So I cannot, for example, whistleblow if I'm dismissed or if I'm harassed. I can whistleblow only if it is about something of general interest. So that's something that is very important. And I can whistleblow only something that in some way has a legal ground or could be true in some way. If I'm going to whistleblow some false reports, the company could even start a criminal case against me and could be for sure could even dismiss the employee. So going very fast, we have two kinds of reporting channel, as you have in USA and UK. There is the internal reporting channel and the external reporting channel. So what you have to pay particular attention for the company is to have implemented all the aspect of the internal channel, because being a whistleblower, one of the first questions that I could ask to the company is, could you explain me if you have put in line everything that is provided by the law in order to receive my denunciation? If not, you are making a wrongdoing. Okay, so I can report externally, for example, at this moment, because normally what you have to do, you have before to report internally, and then if something is not going in the right direction, if they don't respond within 3 months, then I can report externally. And then I'm going to finish my very brief treaty about whistleblowing in Europe. What kind of protection could I have as whistleblowing in Europe? For sure, you can have your job restated, it's clear. You can obtain the compensation for the loss of your income, paid wages, and even future financial losses. And you can be compensated for any other economical damages, such as even legal expenses and cost of medical treatment. It's clear that in Europe, we don't have any kind of rewards that as the one that you have in USA. So that's just a brief introduction, a brief overview of the legislation in Europe. Thank you very much for hearing me.
Thank you very much, Cristiano. And I think that the vast majority of member states have transposed the directive into law now, with a few laggards that might be mentioned. Perhaps we can come back to those later. But I'd love to now introduce Dr. Thomas Rihm to hear from you, to talk to you about the Swiss perspective, which is quite an unusual situation in terms of worldwide whistleblowing laws. Dr. Thomas is the founder of Rihm Law. He's a fantastic lawyer, a member of the LINEE network, always a pleasure to deal with, and he has an interesting and refreshing perspective about some of the difficult situations that whistleblowers have faced dealing with the Swiss regime, and how we see that perhaps where there's no protection at all. It's chastening to hear Thomas speak about this. So over to you, Thomas.
Yeah, thank you. Good evening. Yeah, to summarize a little bit, the Swiss situation is somewhat simple, somewhat perhaps more complex. We have actually a two-class system in terms of whistleblower protection. One class, let's say, is regulated by the current framework we have, and actually we don't have such a framework. We just have the concept of unfair dismissal, and whistleblowing might be considered a case of unfair dismissal. This is the national framework, which is again very, very limited. We had actually fought the first whistleblower case here in Switzerland against the US American Bank in 1995, in combination with the first email discovery case in Switzerland. But at that time, we really had to explain to the employment judge what whistleblowing means and what electronic e-discovery could mean. And at the very end, we won the case. But since then, there were various parliamentary initiatives, to establish a very modest whistleblowing protection system, but this failed again and again. And it's a little bit the cultural aspect, because Swiss people in general, in particular our parliamentarians, think that a whistleblower is still some sort of a traitor, and he should not be rewarded for that. And why does he need protection, if he acts as a traitor? So there's a little bit the cultural background, and there's a lot of educational work to say, look, might be very much to the advantage of the employer as well if he gets reported these instances. But actually no real progress since 95. Now, speaking about the second class of whistleblower protection is that our economy, our businesses are very globally oriented. And if you're as a Swiss company stock quoted in New York or in London or somewhere else, you have all these corporate governance rules applying as well to the Swiss part of the global business, because these global conglomerates, as you know, all have to unify their employment law their employment laws and the pension fund laws and everything. So there's a need to some extent to unify that. And what we see more and more is really the influence of, for instance, if you're suing Novartis or if you're suing Roche or some other large Swiss conglomerate, they have all these comprehensive whistleblower protection regimes, and you can actually base your claims on these general regime. So again, a two-class system. We have a world-class system, if you want, based on private employment laws for these global companies, and the rest has to be happy with what still is in place. That's a little bit the Swiss system. Speaking about this European directive, we're not member of the European Union, so some people are proud about that. Some are not so proud about that, and we're discussing our legal framework with the European Union right now. But we have more the British approach since '92 of joining us further with the European Union. So yeah.
That's very helpful, Thomas. Can you mention maybe one or two of the epic stories of Swiss whistleblowers? Because I thought that the two or three examples you gave were quite illuminating about how they played out in some of the biggest profile cases in history. Do you want to touch on one of those?
Yeah. Of course, I mean, you had this Birkenstock case or Birkenstein case, the UBS guy who earned or could earn at the very end about $100 million. This was basically, he was employed with UBS. I think it was UBS somewhere in the United States. So this was at the very end, a U.S. case, and it was a U.S. tax reward program and all this. So you can't actually consider that as a real Swiss case. But at the very end, UBS was affected by his behavior. Other cases, it's the same. I mean, these are most cases in a criminal proceeding context, where whistleblowers are actually, brought to jail or to preliminary jail, and then they are actually unpacking what they know, and but all these cases are actually not really related to the employment work context, where an employee, sees a wrongdoing and reports that to his superiors and is unsuccessful, and then at the very end goes to the media. That's, in my understanding, the classical system or approach.
Is it very frustrating that you have a very active financial services sector, but you basically have to rely on sort of underlying common law or other countries' jurisdictions? That must be frustrating for a lawyer who wants to have tools to help their clients.
Well, if there is no regime, you have all the possibilities, to shape the the constellations as you like, you know.
Yes,
So
yeah,
now it's
yeah.
not frustrating. The work is not frustrating.
Yeah. Excellent. Well, that's a very helpful introduction. Before I come back to Susan to ask for any other perspectives or questions that Susan has, or help that we can provide to Susan in her valuable mission, are there other comments from the colleagues around the table today? I'd love to hear any other new, fresh perspectives or questions.
Oh my God.
Anyone else? A final call for a word before we go back to Baroness Kramer? Good. No, well, there's been a lot to digest and lots of different angles. Susan, did you have any closing questions, thoughts, or comments bringing this back? And I'd certainly be happy to reach out and kind of introduce you back to the thought leadership within this group, in case there are things you want to find and pick our brains on, because we should collaborate as a group together to move this forward.
Well, that is an offer that is really appreciated. I rather suspect the people on the call don't realize how helpful they have been, because it's been really helpful to me in trying to play through a lot of the thinking as we try and argue for a new framework here in the UK. One of the ideas that might interest you is in the legislation that we have proposed, and goodness knows if this is how it ends up, we looked at an overarching office of the whistleblower. I think it's very helpful, Mary Ingram's description of it as a sort of clearinghouse, you know, to then direct off the various cases towards the relevant regulators, but to keep a watching eye to make sure there's actually an investigation, which is what most whistleblowers desperately want, that it would obviously eliminate the frivolous cases, but also then to provide protection against retaliation. But this is the mechanism that we were thinking of using, which is to say that if there is retaliation, then the whistleblower goes back to the office of the whistleblower, and the office of the whistleblower makes a decision on what we, I think, have called less compensation and more restitution, to try a sort of a make whole approach. That if the entity or the public agency or whatever that is being required to make that payment that objects, it can then take the case to a first-tier tribunal. So in the courtroom, you would have on one side the company or agency that is complaining about the restitution that's been required, and on the other side you would have the office of the whistleblower. And it's been our attempt to change that balance from what is currently a sort of whistleblowing David against a large entity Goliath, that's to two Goliaths, if you like. So I don't know if that is a thought process that might be of interest to some of the people who are involved in this conversation. But otherwise, I just really want to say thank you, particularly around the issues of how, one central office versus sector-based, that the issues of protection versus disclosure, or how you manage to merge the two together, the use of legal firms to play a very important triage role in all of this. I think all of that has been just really useful input. And if people have later thoughts, I would love to hear them.
Well, thank you so much, Susan, because I know how incredibly busy and dynamic you are with your diary, and how hard it is for you to have this sort of time. You've given us a lot of time today, and I really appreciate.
It's quite the converse, Paul. It's these very, very kind people have provided input to me over a couple of hours, and they've been very, very good of them.
Brilliant. And I'm particularly interested in looking at how the Netherlands office of whistleblower is going to work in practice, which Mary mentioned, because I think that will be an interesting lesson for us to look at and to take back. It's hopefully useful for you to know that we will be sharing a recording of this webinar today through social media. Do, if you wish, go away and tweet or put something on LinkedIn or do a link to the recording. If you like, it would be nice to spread the word that people are out there sharing experiences about the whistleblowing climate and your own invaluable contribution in that. So we will hopefully you will see those, and we will try and circulate to everyone here today the kind of links for that. I really want to thank Wayne for convening today, for Cristiano for talking about the European Whistleblowing Directive, which is incredibly important across the member states. For Dave for his really thoughtful and very detailed summary of the whistleblowing laws and the complications that exist in the US, that it isn't a binary situation. For Thomas for the perhaps a chastening situation in Switzerland where you've got to be more creative and more thoughtful about how you protect whistleblowers. And I'd like to perhaps throw it back to Wayne to see if you have any closing thoughts or comments wrapping this up, Wayne.
Yes, thank you very much, Paul. Well, so of course, I'd like to express our regret that Georgina Halford Hall, the CEO of Whistleblowers UK, who was expected to be on the program, was unable to make it today. And I'm sure that we'll share with her a copy of the recording of this event. But we appreciate her participation in the planning for this. Before we end, I would just like to make a pitch for LINEE, the Lawyers International Network for Employees and Executives. We're a small but not mighty network of lawyers in about 10 countries who represent employees and executives exclusively or primarily, and our members have expertise not only in whistleblower law, but in all areas of employment law, including international employment law. We represent lots of expats, for example, U.S. citizens who are sent abroad by their employer or vice versa. So just keep that in mind if you need to find a lawyer to represent an employee, particularly an executive, and you're looking for somebody in another country who might have expertise. Our website is LINEE, LINNE network, all one word, linenetwork.org. And you'll find there a map that shows where we have members of our network who might be able to be helpful to you in any future needs for counsel in other countries.
And equally, we in the UK and in Europe will often get clients who are in Ohio or Maryland or different states and may need state law. So it's really good to reach out and be introduced to lawyers across the range of US and other jurisdictions, because it's so often that contracts or share schemes and other types of arrangements are governed by your law. So it's lovely to have some options to reach out to in those of us who practice kind of cross-border work where we need a friend in every particular location. So we'd always hope to try and be reciprocal and kind of mutually looking out for each other across these sorts of networks.
Yeah, let me make maybe a dangerous offer. Through 45 years of involvement in the American Bar Association Labor and Employment Law section, and also the National Employment Lawyers Association in the United States, I happen to know lawyers who represent employees in practically every location in the United States. And so if any of you are looking for a lawyer anywhere in the United States, look up my email address. I'll give it to you. It's wno@outandgolden.com. And you can shoot me an email and I can send you the name of people that I know and respect in just about any part of the United States.
Fantastic. Well, thank you so much for wrapping that, Wayne. Really massively appreciate everyone's interactive involvement today. And we hope to perhaps run some additional webinars on related topics for executives in our practices, and let's keep in touch going forward.